So when looking at liability in the state of Texas civilly for police officers and the departments they work for, a lot of the analysis starts in section 101.0215, which is liability of a municipality, right? So you work for the city as a police officer, and this is part of the Texas Tort Claims Act that explains what a government can be sued for. So in Texas, governments have immunity, sovereign immunity, and political subdivisions like cities and counties have sovereignty, that absolute government sovereignty from lawsuits. So in order to sue the government, you have to have permission from the government. And there's a list of the things that you can sue for, the subject matters that a municipality can be sued for. And so in 101.0215, right there, number one is police and fire protection and control. Okay. Now, don't take that too broadly, because this means that a cause of action that specifically satisfies the CPRC dealing with police and fire protection and control can be filed. That does not mean a police department can be sued for anything at any time, because a municipality is liable under this chapter for damages arising from its governmental functions, which are those functions that are enjoined on a municipality by law and are given it by the state as part of the state's sovereignty to be exercised by the municipality in the interest of the general public, including but not limited to. So these numbers are the government functions that are assigned a municipality that they are supposed to be dealing with. All right, so, what is qualified immunity? A lot of police officers kind of want to know what this is before we get into the discussion. Qualified immunity comes from the Harlow versus Fitzgerald case. It's a 1982 case where, to just summarize, the court held that public officials are entitled to a qualified immunity from liability for civil damages insofar as their conduct does not violate clearly established rules or laws or policies that protect the rights and of people, right? And you should have a reasonable idea of what those policies, rules, and laws are. So in other words, if you were doing something that would clearly violate protocol or the rights of an individual or the laws protecting an individual under the Fourth Amendment, let's say, for example, you're pulling somebody over on traffic, and they are very disruptive and uncooperative, and they become verbally abusive towards you, and you pull out a Molotov cocktail and you light it and throw it into their car. That would be something that clearly violates the Fourth Amendment, among many others. And that would be something that qualified immunity would not be protected. You would not have, qualified immunity for something like that. Okay. But we're in Texas, right? And so we're looking at Texas laws and how they apply to police officers in Texas. And so, to be succinct about this, the government in Texas has sovereign immunity. You have to have permission to sue the government. Not anybody can just sue the government for anything, much less a government employee for anything. So to find out what different subjects that a city can be sued for, you go to the CPRC, the Texas Civil Practices and Remedies Code, and you look at 101.0215, and that spells out the liability of a municipality. So if your claim does not fall within the listed subjects covered by 101.0215, then you can't sue the government. And you wouldn't be able to sue a government employee. So the person's claims specifically have to comply with this list of subject matter. But the icing on the cake is when you're operating a vehicle, Code 1, right? There's actually a special statute for that. And this is the one that always seems to concern everyone, is if you get involved in an accident when you're driving with your lights and sirens on. So section 101.055 talks about certain governmental functions. One of these governmental functions that is essential, that the government has a monopoly on the power to exercise, is responding to an emergency call or situation from the 911 dispatcher. So in 101.055 paragraph 2, this chapter does not apply to a claim arising from the action of an employee while responding to an emergency call or reacting to an emergency situation if the action is in compliance with the laws and ordinances applicable to emergency action, or in the absence of such a law or ordinance if the action is not taken with conscious indifference or reckless disregard for the safety of others. So what this is saying is, even if you were negligent in the operation of your emergency vehicle, even if you hit someone, if you are driving with your lights and sirens on, you're responding to a Code 1 call, and you're involved in an accident, and it's your fault, there's still no liability. Not for you and not for the government. Because certain governmental functions do not apply to a claim a plaintiff is making against you if that claim involves the action of an employee while responding to an emergency call or reacting to an emergency situation. Now, we all know what an emergency call is, right? You're getting a Code 1 call from your dispatcher and you're responding. Well, and that might even apply in some cases to you're running silent to a burglary in progress because you don't want to scare the burglars away from the residents. You want to be able to catch them in the act. So instead of turning your lights and sirens on, you go Code 1 silent. That too would probably, although there's no real case history behind it, I can make a good case that would not fall within the jurisdiction of the court to hear. Okay, so let's say you're responding to a robbery in progress or a disturbance, and you're pulling up in the parking lot, and you don't have your lights and sirens on, but you're just pulling up into the parking lot, and the suspect comes out and starts shooting at you. You weren't expecting this to happen. This has now become an emergency situation. You're still in your vehicle, you throw it in reverse to make distance, and you back up and you hit someone. That would be an emergency situation simply because you could not have possibly known the suspect was just going to jump out and start shooting at you. And so because you did not have a warning or the knowledge of a dangerous situation that was going to cause an emergency, that you would need to take some kind of action that results in property damage or bodily injury. In that instance, under this section, there would be no liability for either you or the department you work for. So it's important to maintain fact perspective when looking at immunity. There's actually nothing in Texas at the state level civilly that you can be sued for as a police officer if you're acting in the course and scope of your employment. Only the government can be sued. You cannot. The only time you have to concern yourself with personal liability is at the federal level for a civil rights lawsuit. And now let's talk about that.